Welcome, and thank you again for joining today's webinar, The Pros and Cons of an Advance on Inheritance, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address the questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of the Florida Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for 25 years and involved in the purchasing of over $100 million worth of assets. Most of his purchases are pursuant to various state laws, required court hearings, many of which Marc has either attended or appeared as counsel. And as the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. So now, without further ado, let's hear from Marc. Marc, can you start us off today with what ProbateCash does?
Sure. And thank you, Molly, and good afternoon to everyone. I think we have a whole bunch of people, lawyers, paralegals from all over the country viewing, so hopefully this will be informative for everyone. So probate cash advances to beneficiaries of estates who are waiting for their inheritance tied up in probate. I've spent much of my career, as Molly said, providing liquidity to people who are entitled to future cash flows, but don't have the ability to access that cash flow at the present time. And as most everyone on this webinar can attest, I've likely fielded repeated phone calls from frustrated heirs, even your clients, and getting access to an inheritance falls pretty neatly into that category. So most people unfamiliar with probate probably believe that what they see on TV, somebody passes away, you go to the lawyer's office for a reading of the will, if there is a will, and go take off in your car, get some cash, whatever the lawyer says, and that's it. They don't do much probate on television. Most people don't know and learn right before calling your office for help that they can't access the decedent's bank account. They find that out from the banker. They can't sell property or other assets. They may find that from a realtor before trying to sell the real property. Then they call you and learn just what probate is and how long it takes. Then suddenly reality rears its ugly head. Property taxes have to be paid on estate property, repairs made, bills coming in, the usual stuff. And so counting on that inheritance that's going to be now paid out in potentially a year or more is not so much help. And that's the void probate cash fills. We provide a portion of the heir's inheritance with a non-recourse upfront advance, and we wait until the estate assets can be distributed before we're repaid.
Okay, but now how does an advance from ProbateCash actually work?
Sure. So we'll talk directly to the beneficiary who wants an advance. We're probably going to talk to the attorney representing the estate for a little bit of information. We do have a whole bunch of underwriters in our office that are reviewing the public records. The beneficiary will complete a simple application just about the estate, what their needs are, and we can fund them basically in 1 to 2 business days. The goal of an advance is to provide the necessary liquidity to a beneficiary while keeping the beneficiary also engaged in seeing the probate case closed. So we don't purchase the entire inheritance. In fact, depending on the status of the probate case, we may only purchase a small portion of the inheritance. So for example, if the claims period hasn't expired or there's litigation, we'll provide a modest advance at that time. If the case is at distribution and we really know how much money the beneficiary is going to receive, we'll give a much larger advance. So we make advances at each stage of the probate, taking into account the risk at that point and any potential litigation or claims.
Okay, now you've mentioned funding the advance in 1 to 2 business days. How can ProbateCash fund an advance so quickly?
So that's a good question. I've explained what probate cash does, but let me quickly explain what we do not. We're not a lender, which is why we can fund advances quickly. We don't charge an interest rate, we don't do a credit check, and we don't take collateral. So there's no long application process. If the heir can't repay the advance due to an insufficient inheritance, we're the ones taking the risk and will be shortchanged. If a will's challenged, also our risk. If a creditor wipes out the inheritance, that's our risk. The only time we have recourse is if the beneficiary materially breaches our contract, commits fraud, receives the inheritance, for instance, doesn't repay us, because that's just stealing.
Okay, now circling back on the title of this webinar, what are the pros and cons of an inheritance advance?
Sure. So these advances may not be for everybody. In fact, they're not for everybody, but
Mhm.
they're definitely for some who need it. So the pros of getting an advance from probate cash against your inheritance. Number one, it provides you with immediate liquidity against your inheritance. So as anxious heirs are calling you because they have bills to pay, they have their necessities, we can provide that money to them quickly. Number two is that they take pressure off of the personal representative. They take pressure off of you, perhaps the lawyers, paralegals in your office. So they're calling for money. We can reduce that pressure, which money does. It reduces the pressure. Um, the cons are, it's an advance that's expensive. Our fees are expensive, and it's not for everybody. And I encourage all folks who do business with us, and encourage lawyers, paralegals, that if the beneficiaries have other means to get money against their inheritance, or money just period, they should do that. They should pursue those means. If they can get institutional funding and have the time to go through a loan process, they should probably do that. If they have family who can lend them money, they can do that. Another reason why, though, however, it may make sense for somebody to take an advance against their inheritance is, I mentioned, the non-recourse aspect. So you don't know what's coming until it comes down the line. If there are claims that may come down and wipe out the inheritance or significantly reduce the amount of the inheritance, or there are other challenges, remember, our advances are non-recourse. That's our risk. We take that risk. And if a claim indeed comes in and wipes out that inheritance, well, at least the beneficiary receives some money.
Okay, now speaking of beneficiaries, how does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? Also, how does an advance affect the probate case?
Sure. In short, it doesn't. An advance to one beneficiary shouldn't affect any of the other beneficiaries who are not asking for an advance, and it shouldn't slow down the probate case at all. We are in contract privity with only the beneficiary who is assigning their inheritance. So if that beneficiary breaches the contract or they don't get the inheritance, we don't look to the other beneficiaries for the shortfall. They're not involved in it. So there shouldn't be any effect. There is no effect to the other beneficiaries. And the probate case will not be slowed down either. However, we do file the inheritance assignment in the probate court. We want the judge to see that the assignment, that the inheritance is being assigned. We, of course, want you guys, the lawyers, the paralegals, to see that the assignment is out there. We don't want any surprises. So transparency is incredibly important to us. So people getting surprised, that's when issues occur. So we like to deal with all of that up front.
And staying on the topic of beneficiaries, can multiple beneficiaries get an advance from probate cash?
Absolutely, and they often do. So many times we'll do an advance with one of the beneficiaries. They receive their money. They're able to use the cash to help them out. Other beneficiaries see the benefit, and we often then get the phone calls from those beneficiaries who are requesting advances. So it's pretty common when one estate, we have advances out to more than one beneficiary.
Okay, now how can probate cash help law firms?
So we work with a whole bunch of lawyers throughout the country. uh, Lawyers are looking for clients like everybody else, and they have significant marketing expenses. So you're marketing for clients, and you're hoping to get a retainer most of the time when you find those clients who want to retain you to open up a probate. Many of those folks do not have the money to pay you a retainer, not even for the cost to open up the probate. So if there's real property that's going to be sold in the estate, probate cash will make an advance to the person, the beneficiary who is applying to have the letters testamentary, will make that advance. That person can authorize us to pay the advance directly to your office. So we're still in contract privity with that beneficiary, but they'll be authorizing us to make the advance directly to your firm, and your firm will then have the money, the retainer, and the money to cover your costs. And now you're not waiting for the probate to end. That risk is again transferred to us. That's first and foremost. Second, of course, we mentioned it before, is so many lawyers, paralegals are getting constant phone calls, sometimes angry phone calls from people who aren't your clients, or just beneficiaries, not understanding why the probate case takes so long. and where's their money. Again, referring them to us will make make those phone calls stop ringing. And also, we have a lot of experienced folks working at ProbateCash, and so not only are we giving those beneficiaries advances, but we can also update them with how the probate case is progressing through the courts, and so we can help them manage their expectations with each, if it's in the claims period, if it's out of the claims period, whether their assets being sold, because we're constantly following the progress of those cases.
Okay. Speaking of cases, are there any laws that govern the inheritance advances?
There are not a lot, but there is one, and that's in California. So California does have a statute in the probate code that governs the assignment of an inheritance. It's a probate section 11604.5. 11604.5. And it gives guidance, and not just guidance, it requires you to follow that statute, which are, if it's California, a lot of consumer protection laws that are within the probate code. And it also, we file the assignment with the court, and California we like because it requires the probate attorneys in California to include us in the petition for final distribution. It's a much cleaner way. We actually follow the spirit of that statute in every state we do business with, and we do business in almost every state in the country. We've then, and that includes, of course, filing the assignment with the court to make sure that there are no surprises, and the judge, personal representative, the estate attorney has notice, and any questions can be asked at that point.
Okay, wow. We're almost at that 15-minute mark. And as promised, Mark, I know you're going to stay on to answer everyone's questions. But if you need to leave now, we're going to send everyone a link to the recording of this presentation and the questions and answers. I also want to give you Mark's contact information real quick, just so you have it. You can call Mark at 561-476-0018 or email him at Mark, and that's MARC, at probatecash.com. Okay, so let's get to y'all's questions. Number one, just to be clear, as their attorney, how do I help my client qualify for an advance?
So as far as your client, it may be a beneficiary of the estate, not just your client, and you can help by really just having the probate information. If you know of any claims that may be coming down the line, that's helpful. If how the assets are going to be sold, any information you may know about the case that can just expedite our comfort level in providing an advance to the beneficiary, that helps. So having the case number, of course, is helpful. If you're sending somebody over to us before the petition is filed, so going back to the moment where somebody wants to get money to pay you the retainer and authorize us to pay the advance to your office, what we really want to do is confirm that there's an estate asset that's real property, and that real property is going to be sold. So, what are some of the issues that we have in that real property? Is somebody still living in the house? Do they have plans to move out of the house or not? What we don't want to get into are evictions. We don't want to get into litigation that we need to participate in to try to obtain our advance, because beneficiaries, especially our customer, is not cooperating and using their reasonable efforts to get the probate case moving and have everybody paid their inheritance.
Okay. Another question I see here says, as an attorney for the estate, can I be held responsible if I talk to your company about advance or if you don't get repaid?
So no, unless you're really committing fraud, no.
Mhm.
As an attorney for the estate, I mean, you probably want to send somebody over to our office to again make your phone stop. Somebody needs money. You should know that this service exists. I mean, you are an attorney, you're a paralegal. You should have all the tools at your disposal, including ProbateCash, because people need money. And not only that, but personal representatives need money. The estate needs money to pay taxes, to fix up the houses, so you can get fair market value. $20,000 into a house can be a six-figure difference in what the fair market value is when you sell the property. And of course, that benefits all the beneficiaries, more assets in the estate. So remember, we're also just in contract privity with the beneficiary. We're not in contract with the attorney. We're not in contract with the estate. just us and the beneficiary. So we are not relying on any representations or anything like that of the lawyer in our underwriting process.
Okay, now we have another question here. It's about fees. So what are the fees?
Okay, well, that didn't take long to be asked. So that's an important question. As I mentioned, these advances aren't for everybody. So our fees start at 25% of the advance amount. And so the fee structure depends on when we get paid back. And they can be higher than 25% if the advance stays out for many, many months. And the advances, though, however, can be repaid at any time. Um, so it's something that you should discuss with your client, or we'll discuss with the beneficiaries. We're also very not just transparent in what filing documents with the court. Our contracts are very clear. They're written in layperson um, uh, in a layperson manner. We also, before we fund a beneficiary, we conduct a recorded call with the beneficiary to make sure that they understand the advance they're receiving and the fees that they're going to be paying us back, what the advance amount will be when they pay us back, depending on the timing of that. So not only do we have a contract, but we also want to make sure that we have that call recorded, so there are no questions that nobody had a misunderstanding.
Okay, now also here the question is, can you get an advance before the probate case is open?
So as we said, we have a whole bunch of people, a big network of lawyers and paralegals where advances are coming before for the purpose of opening up the probate case. So can you get one before the probate case is open? If you think mom or dad is going to pass away soon, can I get an advance before that? No. Can you get it in advance to buy a car, to pay for tuition before the probate case is open? No. Before the probate case is open, we will make an advance for the purpose of opening up the probate case. That advance will be paid to the lawyers, maybe a nominal advance to a beneficiary, depending on the circumstances. But as you can imagine, we don't know what's coming before the case is opened, and
Mhm.
we go baby steps in these transactions. So the idea is to be as efficient as possible with these advances.
Okay, great. I'm just going to pop over and make sure we got everyone's questions. And it looked like we did, but if you're like me and you think of something 15 minutes later, I'm going to give you Mark's information once again so you can contact him offline if any questions or comments pop up later. Again, you can call Mark at 561-476-0018, or you can email him at mark, and that's MARC, at probatecash.com. So thank you everyone for joining us and for your questions, and have a great day.
Thanks, Molly. Thank you, everybody. Take care.